Tēnā koutou katoa. And thank you especially to my Centre for Justice Innovation bodies who have come along today. My family have to, but they didn't have to, so thank you. I should warn that the comments I'm going to make today do include some comments about and references to sexual violence, so just to let you know and prepare you for that. A little bit about me. I grew up in the Thatcher years in Britain in a coal mining village, and that's relevant because there I saw the criminal law in action. And I saw that it wasn't just about the letter of the law itself, but it was also about where you hung out, who you hung out with, what police officers and other officials decided they wanted to do with you if they found you doing something that you shouldn't. In other words, my early experiences gave me insight into the fact that the law operates within a social context. And that's always shaped my work, this idea that the law operates within a social context. So my work tries to marry different research threads to produce evidence that not only leads to legislative and procedural reforms, but also to practice change that's mindful of the experience of the participants who work in or have to travel through the criminal justice process. And that's where the title of my presentation, Hurling the Little Streets Upon the Great, comes from. In the poem No Second Troy, getting a little bit of English in, W.B. Yeats refers to the futility of ordinary folk fighting the powerful. And it can feel like a continual hurling of the little streets upon the great to be a socio-legal scholar focused on criminal justice, when the immediate tough on crime rhetoric often overshadows the evidence that you gather. So a lot of reform in the area that I work in reflects law's self-image of objectivity, focuses on change to the law itself, trusts, usually incorrectly, that neutral laws, so-called neutral laws, will be experienced equally by different people. In the law's bid for efficient, unemotional and objective decision-making, we so often lose sight of the human beings and their stories at the heart of any criminal legal dispute. And not infrequently, the side effects on participants in the process are either minimised or not factored into criminal justice reforms at all. We also know that the rules of the criminal process are not always adhered to, or that there are gaps that are left, that discretion fills. And popular perception focuses in on conviction and sentencing, but my work tries to go broader than that because it's clear that cases don't have to result in conviction in order to have a detrimental impact on the people who are going through the criminal process. Hence the famous phrase I've got on the slide there, that the process is the punishment. So what I've done, rather than trying to kind of talk to you about, hey, here's some work I've done, is try and build that through a little scenario. And I should have thought, Nicole, to include my colleagues' names in this. But instead, I've done a scenario about Max, someone called Max. So here we have Max. And what I'm doing here is trying to show you that the need for legal research and reforms that take account of social context is there at all stages of the criminal process. Now, this scenario includes real events. It includes quotes from participants in some of the studies that I've done, but obviously Max is not one person. Okay, so Max, we're going to say that he's a 22-year-old man. He's been arrested on sexual offending charges. He's got only one serious previous adult conviction for assault with an intent to rob, but he's got a long history of juvenile offending behaviour and a difficult family background that was divorced from his cultural and familial supports. And he says, growing up, sometimes I felt like I wasn't loved, but on the street with the street kids, when we were running amok, I felt that I was loved. I think it started at 9 years old. Yeah, I was getting into trouble, but wasn't getting caught until 13 onwards. And the combination of his previous adult offending and his current charges mean that there's what's called a reverse onus when he gets to court, whereby he must satisfy the judge on what we call the balance of probabilities, which just means more probable than not, that if he's bailed into community, he won't commit any offence involving violence or that causes danger to others. And the judge decides that the risks of Max offending while on bail can't be mitigated by ordinary bail conditions. So they conduct a report to think about electronically monitored bail. And that report suggests that his flatmates don't consent to having checks at home. So because of a lack of suitable accommodation, Max is remanded in custody. His partner's upset and rushes from the courtroom, leaving their 4-year-old child in there, crying for daddy in the public gallery. And Max is unable to move from the dock in order to comfort her. So then we have Max there on custodial remand. It's first kept in a police operator justice facility, as there are no remand beds available in prison. He's allowed out of his cell for 2 hours a day in order to exercise, make phone calls, shower, the lot. The space is small, there's no fitness equipment. He arrived without spare clothes, including undies, and none are provided for the 4 nights he's there. He's then moved to a prison remand unit, and there he encounters pressures to join a gang. And he said he joined one because he felt compelled to pick a side to avoid being beaten up. And he says, I thought I'd go inside, study the Bible, train every day, get on a vegan diet, this, that, get out with abs. I thought that's what it's going to be. But I walked in there and I seen the boys in there and they're like, yeah, come with us, do this, do that. And I just walked into trouble, more trouble. He tries to get his partner's number on the approved list for phone calls, but due to staff shortages, that takes a few weeks, and he becomes paranoid about her safety and fidelity. The lack of an end date to look forward to is exacerbated by the lack of educational or life skills programs, by hours of inactivity in his cell. He's neurodivergent. That's not screened for. No accommodations are available. He finds the noisy environment in prison really difficult. His mental health suffers. He finally gets a medical visit where all he's given is sleeping pills. The unit's understaffed. Max is kept in his cell for 23 hours every day, and he says the days are too long, waiting for a bomb to go off. After 5 months on custodial remand, with still no trial date, he's lucky, and he secures the support of a bail accommodation provider. He's released on electronically monitored bail, wearing what he had on when he was arrested, which does not include shoes. He has a bus pass issued to him, but little other support to get to the bail accommodation on time. Meanwhile, Max's alleged victim is a notified victim who should have been told when he was bailed, but unfortunately communication breaks down. She finds out through social media when he's released. Then after delays, it's time for trial. Max's partner's in court, again with his child. This judge doesn't think it's a suitable environment for children and states they're not allowed in court. So the now 5-year-old is sent to wait on chairs outside the courtroom alone until a friend can pick them up. It's a jury trial. It involves issues of consent. The jury struggles with the evidence, which is finely balanced. And one juror says, I think both parties were at fault in some ways. They were drugged and pissed and in some very bad headspaces. In fact, we decided in the jury room, we just wanted to take them and bang their bloody heads together. She struck me as, I think she's learnt her lesson. While the complainant's judged for being drunk and taking drugs, jurors think that Max slipped up and was naive for drinking too much. They expected to see a brute in the dock, not a clean-cut family man. Max is found not guilty, but he can't get his job back, nor the family time he lost while he was awaiting trial. The jurors, well, they struggled with the weight of responsibility that the case placed on them. Some of them reported feeling physically and emotionally unwell for weeks. The lawyers are affected too. The system moves them on to the next case file before they've processed the impacts on them of running a sexual violence case. Their occupational culture demands that they just get on with it. But long term, it may affect their ability to do a good job. They might become cynical about human nature, hypervigilant about their safety and their loved ones, and develop unhealthy coping mechanisms, such as alcohol misuse. So that rather dismal scenario, sorry to bring you all down this afternoon, that's my life, highlights areas where there have been or could be legislative reform. So changes to bail laws, minimum standards for detention, those kinds of things. But most of the difficulties that that scenario throws up are not about the law itself, or at least not only about the law itself. It also involves things like legal practice, discretionary decision-making, legal policy, gaps in departmental policy. The reform of the law alone is not going to fix those problems. So protocols about children in court, assistance to someone bailed when leaving remand in custody with no shoes on, lawyer and juror well-being, none of that is going to be fixed by changes to the law itself. So my life work really is about thinking that reform of the law is an important part of what I want to influence. But I've also come to understand that changing the law isn't enough to really change participants' experience of the process. The law is mediated by people and by other system and social drivers, things like delays, lack of supports, lack of suitable accommodation, like for Max, social biases, systemic racism, socioeconomic factors, media reporting, on and on and on. I could go for another half an hour. Yeah, 1 minute left. Qualitative empirical legal research, such as the stuff that I do, tries to cast light on the places where the law is failing people. It requires innovative thinking about doing justice in new ways, responding to community needs. It can be really satisfying because the implementation of a small change to practice can have a large impact on the process as a whole, but it also feels like a never-ending game of whack-a-mole. And just to finish off, I was once at a conference with a friend, and it always keeps coming back to me, and a research collaborator of late, who said to me, I wonder why it is that criminal justice researchers seem like the most optimistic, upbeat bunch of people in the face of the kind of work that we do. And we agreed that it's because of the kind of work that we do that we're like that, because you need resilience to keep on hurling the little streets upon the great. Thank you. Yeah.
Wow. Yeah, that was great. Thanks, Yvette. Yeah, we've got time for a question. Anyone? Sorry, Rod, you missed out, but Yvette kept to time, so she gets a question.
The only reason I bought notes was so we do that.
There we go.
Is there a country that has a model that we should aspire to?
I think there are countries from which we might want to take some things and some approaches or attitudes. And, people always say the Scandis. And I think that's an easy one to go to. But then again, traditionally, they've had a much more homogenous society. So I think looking at places like the Netherlands might be more fruitful, where they've made some significant changes recently. But I can't think of a country where they've got it perfectly right. In every country I look to, there are groups of society where the criminal justice process is harsher than for others. So nowhere's got it perfect right now, but there are some places that do some things better than us, for sure.